Towards a More Perfect NEPA, a case study of the Dakota Access Pipeline and Standing Rock Sioux by Isaac Smith, Winnie Brown, Annika Thompson, and Cornell. We will be discussing the Dakota Access Pipeline and the conflict with the Standing Rock Sioux. We will begin with an introduction to the Dakota Access Pipeline. We will then discuss the National Environmental Protection Act, also known as NEPA, as an institution, cover the acts potentially violated by the Dakota Access Pipeline, explain the role of NEPA in the case of the Dakota Access Pipeline conflict, and make suggestions for modifications for NEPA moving forward.
The Dakota Access Pipeline runs from Bakken Shale Field in North Dakota to processing facilities in Illinois. The original route was scheduled to go above Bismarck. However, there were concerns about the pipeline's proximity to the city's water supply, and so the pipeline was rerouted without any sort of protest.
The two primary stakeholders are the Standing Rock Sioux and Dakota Access LLC, which is a subsidiary of the multi-billion-dollar oil and gas company Energy Transfer Partners.
Protests have been gaining national attention at the site of the Dakota Access Pipeline. Standing Rock Sioux, allies from over 300 Native American tribes, as well as environmentalists and other supporters, have been at the site since the spring of 2016, engaged in what they call peaceful and prayerful protest. However, the North Dakota governor has called in the National Guard and police forces from neighboring towns to disperse protesters and allow for continued construction of the pipeline. Police forces have become increasingly violent, using tactics such as rubber bullets, water cannons in below freezing weather, pepper spray, tear gas, and concussion grenades. People have also been arrested for recording and reporting on protest conflicts with police and with the National Guard, which many consider to be a free speech violation.
NEPA is an institution as it sets the norms for how environmental impact assessments regarding federal and private projects are carried out. NEPA intends to coordinate government actors, members of civil society, and private sector agents as it mandates that relevant agencies and cooperating companies pay attention to the environmental impacts of their ongoing projects. NEPA requires that the lead agency releases conclusions gathered through the NEPA process to the public and solicit comments in response. But NEPA is not a substantive act. It only determines the procedures for review, and substantive acts such as the Clean Water Act, Rivers and Harbors Act, and the National Historic Preservation Act determines what potential environmental and historical impacts the company and lead agencies should consider. A successful adherence to NEPA is intended to add legitimacy to a project in the eyes of civil society. So the NEPA process begins with the agencies in charge, otherwise known as the lead agency, delivering a categorical extension for projects with low projected impact or delivering an environmental assessment for projects that may have significant environmental impacts. An environmental assessment looks into whether a project will deliver significant environmental effects to require an environmental impact statement. Of course, a project can go straight to the environmental impact statement process if significant impacts are known to exist, but due to the high cost associated with the environmental impact statement, it is rare for it to happen. While the environmental assessment and the environmental impact statement both have commentary processes, it is the environmental impact statement that is reviewed with the EPA and the Council on Environmental Quality. An environmental assessment is not reviewed in this way, and if finding no significant impact occurs, then the EA does not go on to the EIS, the environmental impact statement. The commentary process of the environmental assessment is not substantive, which is one of the primary shortcomings of NEPA that lead to the Standing Rock protests, as people feel they were not sufficiently represented.
In their lawsuit, the Sioux claim that the Dakota Access Pipeline violates the Clean Water Act and the Rivers and Harbors Act. Section 14 of the Rivers and Harbors Act requires that the Corps ensure that a project is not injurious to public interest. This requires a public interest review. However, the Sioux argue that the pipeline's public interest review is not legitimate because it weighed the benefits of the entire pipeline against the costs of small sections of the pipeline. Additionally, every water crossing in a project requires a Section 10 permit from the Rivers and Harbors Act. The entire Dakota Access Pipeline is permitted under a nationwide Permit 12. However, to maintain this status, a project must meet several general conditions. The Sioux argue that the Lake Oahe crossing does not meet Condition 7, water supply intake, and Condition 17, tribal rights, because the pipeline is incredibly close to the reservation's water supply intake, and if the pipeline were to break, the oil would likely spill the half mile into the reservation, not only destroying their water supply, but also several historical sites. Therefore, the Lake Oahe crossing requires an individual permit. For a project to maintain its nationwide permit status, while a specific crossing requires an individual permit, the entirety of the project outside of the individual crossing must have functional utility. However, since the Dakota Access Pipeline is a pipeline, it does not maintain this utility without the Lake Oahe crossing. Therefore, the Sioux argue the Corps should revoke the project's Nationwide Permit 12 status.
The National Historic Preservation Act was put in place to preserve historical and culturally significant sites when considering large-scale projects. It is overseen by the Advisory Council on Historic Preservation. In this case, an NHPA Section 106 requirement must be fulfilled in order for a federal agency to issue a license for any undertaking, which means historically significant properties that could be potentially damaged must be considered before proceeding. This entails the review of sites by the U.S. Army Corps of Engineers, including surveys, interviews, and consultations with the tribe. These surveys will result in either a finding of adverse effects or no adverse effects. And if adverse effects are found, there will be a memorandum of agreement with the Tribal Historic Preservation Officer, which is essentially a plan to avoid or mitigate harm. Despite the Sioux's status as a sovereign nation, this process is almost always completed very much on the terms of the Corps, which is a complaint that the Sioux have made time and time again during this process. The tribe claimed that the Corps violated the NHPA on 2 counts, the first being that when the pipeline was given Nationwide Permit 12 status, the Corps pre-authorized construction and thereby delegated cultural surveying responsibilities to Dakota Access, which should legally be the Corps' responsibility. The Advisory Council on Historic Preservation agreed that it was unlawful to delegate this responsibility to Dakota Access. However, the Corps avoided legal action by responding with a memo which essentially read that they had overseen the Dakota Access surveys and agreed that they had no issue with them. Since Dakota Access has vested interest in finding no adverse effects and moving forward with the project, the Standing Rock Sioux took great issue with this process of conducting private surveys. The other violation was that the Corps did conduct historical reviews at all 204 water body crossing sites that they needed to issue permits at. However, they did not consider the entirety of the pipeline when conducting their historical and cultural reviews. This brings into the equation indirect effects, which were not considered by the Corps and which the Sioux consider detrimental to their culturally significant sites. This includes sites that are not near water crossings, as well as sites that may be affected by indirect aspects of the pipeline construction, such as access routes. The Corps came to the conclusion that there were no adverse effects with the current pipeline route, despite the fact that they destroyed a known burial ground. And throughout the process, the Corps claimed that the Sioux were contacted but did not respond. However, the Sioux responded to this claim, saying that they were unwilling to participate in surveys that they considered insufficient.
Dakota Access followed NEPA procedure and submitted a 136-page environmental assessment in which they declared a finding of no significant impact. The finding was confirmed by Anthony Mitchell and John Henderson, district commanders for relevant North Dakota Army Corps departments. The Fonzie ruling sparked a lawsuit from the Standing Rock Sioux in cooperation with the environmental nonprofit Earth Justice, as well as months-long protests. The U.S. Army Corps of Engineers ultimately denied the easement for the Lake Oahe crossing on December 4, 2016, requiring a full environmental impact statement.
In review, the Army Corps was accused of violating the Clean Water Act, the Rivers and Harbors Act, and the National Historic Preservation Act, and carrying out an insufficient environmental review as required under NEPA. We feel that the environmental review process should have revealed tribal concerns and led to a reevaluation of the pipeline route. NEPA's failure to address the pipeline's potential for environmental and historical impacts suggests a need for revision.
While we do have several suggestions as to how we would consider reworking NEPA, we wanted to take a moment to recognize several positive impacts that NEPA does have on projects such as the Dakota Access Pipeline. For one, it inflates the cost of projects, delaying the process so that political opposition can be built. It also brings sunk costs to economic stakeholders, which can make them reluctant to change their plans, therefore potentially leading companies and lead agencies to prefer thorough surveys from the start to avoid the process of rerouting later in favor of decreasing costs.
We recommend improving the drafting process by requiring greater involvement of environmental experts at all steps of the process. Additionally, the environmental assessment is only reviewed by the lead agency, which may not have environmental expertise. Currently, the EPA isn't involved unless it's an environmental impact statement, but we recommend having the EPA review all environmental assessments before the FONSI is approved. There is precedence for this, as the EPA have been co-lead agencies in the past.
One other significant improvement that can be made to NEPA is the implementation of after-the-fact monitoring. Currently, the EIS process requires comprehensive environmental impact assessment, but no monitoring after the project has been carried out. This creates incentives for agencies to produce EIS with large quantities of information to defend against potential liabilities, but provide very little environmental protection from the actual impacts of a project once carried out. In fact, the number of EISs over the years have decreased, and EAs outnumber EIS by a factor of 100 to 1. Most EAs produce findings of no significant impact. NEPA should focus on achieving tangible results by incorporating ex-ante monitoring. As the environment is dynamic and unpredictable, the EA and EIS process cannot possibly capture all distinct possibilities of risk. By focusing on high-risk issues in the EA and EIS and using adaptive management afterwards to mitigate the issues as they come up, NEPA can become a more wholesome process for environmental protection.
We recommend a mandatory consent-based negotiation process for projects that may impact American Indians. We suggest that the additional clause to NEPA be modeled after Article 32 of the UN Declaration on the Rights of Indigenous Peoples, which states, "States shall consult and cooperate in good faith with the indigenous peoples concerned through their own representative institutions in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources." This will codify greater institutional plurality by raising a marginalized part of civil society from commentators with little power to the position of equal negotiators with members of government and the market. A strengthened NEPA is an important step towards ensuring environmental sustainability and environmental justice.